My husband filed emergency custody of our 6-year-old and told the court I was too unstable to parent. The same morning, the school called. A trust payment had been put on hold, pending custodial verification. I thought he was attacking me. Then I realized the petition and the school call weren't separate things. He's the father. He can say every word of that petition with a straight face, because some of it was true. I was overwhelmed. I was not unstable. There's a difference, and I had to trust the law to see it. But what I couldn't stop coming back to was the date, not the date he filed. Today before it. 4 days before it. Something happened 4 days before he filed, and he never mentioned it. He was counting on me not finding it. So I called my lawyer. He's going to say he did it for his child. You're going to want to believe him. Stay long enough to see the date, and then tell me what you think he filed it for. The call connected on the second ring. Urgent, I said. I needed Sibylla today. Then I hung up and stood in my kitchen and read the petition again, not for what it said about Blaze, for what it said about me. Emotionally overwhelmed, unable to provide consistent and stable care for the minor child, demonstrating patterns of withdrawal and unilateral decision-making that exclude the biological father from meaningful participation in the child's daily life. 68 pages. They built 68 pages of that in 48 hours. That's not grief. That's preparation. I want to tell you I was outraged. I was, underneath. But the first thing I actually did was read it like a document, not like an insult. I looked for the legal standard buried in the language, the threshold they'd have to meet to prove any of it. Because that's what I do. That's what I've always done. I read the structure before I read the emotion. And I know, sitting here telling you this now, that quality saved me in that courtroom. I also know it's the same reason I was standing in my kitchen on day 1 instead of having seen it coming weeks earlier. You read the structure and you miss the person who wrote it. The school called before I finished the second page. The bursar's voice was the particular kind of apologetic that schools use when they've been instructed to say something unpleasant, but professionally. She told me a trust-funded tuition authorization for the current term had been placed on administrative hold. She told me they couldn't process the payment until custodial status had been clarified. She told me they'd been advised, her word, advised, that a custody petition was pending. I said, "Who advised you?" She said she wasn't able to share that. So, my husband's legal team had contacted my child's school before I even knew the petition existed. They'd called ahead. They'd arranged the hold before the paperwork landed on my counter. The school was already in motion by the time I was reading page 1. I looked at the sealed envelope they'd sent. Cream, formal, tuition authorization, action required. And I thought, he planned this sequence. He didn't file and then the school happened to call. He filed and then the school called because of how he filed. I picked up the school envelope and set it on top of the petition, not beside it anymore, on top. It felt important to put the child's thing above the legal thing. I don't know why, it just did. Then I changed out of the robe, put on the first real clothes I could find, black turtleneck, dark jeans, and I waited for Sibylla's office to call me back. I sat at the kitchen counter in my real clothes and I waited, and I did not open the envelope. Not yet. I wasn't ready to see the number, the tuition amount frozen, the term officially in suspension, because I knew if I looked at it I'd stop being functional, and I needed to stay functional. Sibylla Argos has been practicing family law for 27 years. She has the kind of office that says she doesn't need the office to tell you she's good. No awards on the wall, no framed degrees, just a dark wood conference table and a window and a stack of documents in precise order. When I walked in, she was already seated. She didn't stand. She looked at me the way she looks at briefs, like she's already calculating what's missing. I sat down and I told her everything. In the order it felt important. The filing, the emergency designation, the instability framing, emotionally overwhelmed, unable to provide stable care. The fact that there had been no conversation, no mediation, no warning before 68 pages of legal argument appeared on my counter. The fact that the school had already been contacted. I talked for, 10 minutes, maybe 12. She let me finish. She didn't write anything down while I was talking. She was watching me. Then she asked one question. Tell me about the child's trust. Not the filing, not the marriage, not the instability framing I'd spent 10 minutes laying out. The trust, the one thing I'd mentioned in passing, the one sentence I'd almost moved past because it felt like a separate matter, financial, not custodial. I almost skipped it entirely. I know that now. I walked her through the Prado Child Protection Trust, $18 million established 5 years ago, the structure, the disbursement rules, who authorizes what, and then I said, almost as an aside, the way you mention a detail you don't think is relevant, that major disbursements required authorization from the child's primary legal custodian of record, verified by the trustee before distribution could occur. Sibylla picked up her pen. She put it on the document in front of her, the trust summary I'd brought with the filing, and she drew a circle. One clean circle around that clause. She didn't underline it. She circled it the way you circle something you were looking for. Then she looked up. Her face gave nothing away. 14 years of practice, and she already knew which thing was actually on the table before she said another word. She asked me to get her the full trust documents and the trustee's contact information. Alonzo Mireles. She wrote the name down. Then she said, "Don't open the school envelope yet." I said, "I haven't." She nodded once, like that was the right answer and she'd been checking. I left her office not knowing what she'd seen, but I knew she'd seen something. There's a quality to Sibylla's silence when she's found the thread. A particular stillness. The pen down, glasses off. I'd heard about it from a friend who'd been through her own version of a custody situation 3 years ago. My friend had said, when Sibylla goes quiet, it means she already knows how it ends. Sitting in my car outside her office, I thought about that. I hoped she meant it the way I needed her to mean it. I got home just after 5. I changed back into the turtleneck without the blazer. The blazer felt like something I'd been wearing for armor, and I needed to take the armor off to think clearly. I sat at the dining room table, not the kitchen counter. I was done with the kitchen counter for the day, and I opened the petition again. This time I didn't read it as an accusation. I read it as a document. There's a difference, and it took me the whole drive home to make the shift. An accusation you defend against. A document has a date, a structure, an author, a sequence of decisions. I was trained to read structures, so I read it like a structure. The date at the top was 3 days ago, filed the morning of day 1, the filing stamp confirmed. The motion was designated emergency on the basis that the child's welfare required immediate judicial attention. Emergency designation is not automatic. Someone has to certify the basis. His lawyers had done that, which meant this had been in preparation before day 1. How far before? I picked up my phone and I went back through the last month of messages from Blaze. We'd been communicating about pickup schedules, school events, the logistics of a separation that was trying to be functional without being comfortable. The messages from 3 weeks ago read like 2 people doing their best, short, civil, task-focused. Then moving forward through the weeks, something shifted. His responses got shorter, single words where there had been sentences, then longer gaps between replies. Then in the last week before the filing, 3 days of nothing. He went silent, and when I looked at the date his messages stopped, really looked at it, placed it against the filing date, there was a gap, a specific gap, not a random silence, a silence with edges. I didn't know what filled that gap yet, but I knew something did. I got a pen and I wrote the filing date on the notepad I keep by the table. I stared at it. I wrote a question mark beside it. Then I wrote the date his messages went quiet. Another question mark. 4 days between them. maybe less, maybe exactly 4. I called Sibylla. It was after hours and I knew she wouldn't pick up, which was fine. I didn't need her to answer. I needed to say it out loud so it existed somewhere other than my head. I told her voicemail, "There's something about the date, the filing date, and the days before it. I don't know what yet. Can we talk in the morning?" I sat at the table for a while after that, the notepad in front of me, 2 dates and 2 question marks. I've been thinking about that piece of paper ever since, not because of what it said, but because of how I felt writing it. Not afraid, not angry, just certain, the way you're certain before the evidence arrives. I'd been in Sibylla's conference room before, once when I drafted the original trust documents 5 years ago. Different season, different version of my life. The same dark wood table, the same window with the city below it. I didn't think about that the first time I came in about the custody case. I thought about it that morning. The trust document was already open when I sat down. Sibylla Arcos, my attorney, was standing, not seated, which I'd never seen before. She read without preamble. Major disbursements require authorization from the child's primary legal custodian of record, as verified by the trustee, prior to distribution. 1 sentence. She let it sit. I'd read that sentence before. I'd signed off on it. I helped write the parameters that sentence was meant to enforce. But I had never read it as a target. And that morning, in that room, I read it the way Blaze must have read it, as a gate with a specific key, and the key wasn't money. He has $220 million. The school fees were $48,000 a year. If this was about the money, he could have written the check himself without calling a trustee. The key was standing. The key was the phrase, primary legal custodian of record. Sibylla said, "An emergency petition, if granted quickly, before the trust administration has time to formally respond or challenge, could create the appearance of primary custodial standing, a fast ruling, a changed status, a trustee who now has to recognize a new parent of record." She read it with the particular weight lawyers give to sentences that are about to cost someone something, word by word, no skipping. I sat with it. And then I said the thing out loud that I'd been circling toward since the school called the morning before. He wasn't trying to take our child. He was trying to become the parent of record. Sibylla looked at me. "Keep going," she said. I thought, how long? That was my next question, and I couldn't say it yet. How long had he been looking at that clause? Was it recent? A decision made in the weeks after the separation when the trust administration came up in logistics? Or was it older than that? Had he sat across from me at dinner somewhere, knowing, while I passed him the bread? I didn't ask. I already knew the answer was going to be worse than I wanted it to be. And Sibylla had more to show me. Sibylla sat down. She pulled a document from the second folder, separate from the trust documents, a different letterhead. She slid it across the table to me. Alonzo Morales, the Del Prado Trust's acting trustee, keeps a request log, standard fiduciary practice, every formal communication about the trust, time-stamped and filed. I looked at the document. It was 2 pages. The header read, Del Prado Child Protection Trust, Access Request Record. The first entry was from 5 years ago, routine, administrative, my own signature in the authorization field. The second entry was recent, very recent. The request was filed by Blaze Weatherby, submitted through his legal representatives. It asked for disbursement access authority, specifically the ability to authorize trust distributions as a parent with standing over the child's welfare needs. The request was reviewed. The trustee noted the request was irregular given the pending separation. He asked for supporting documentation of custodial status. No documentation was provided. The request was denied. The date on the denial was 4 days before the custody filing. I had the notepad in my bag, the one from my dining room table with the 2 dates and the 2 question marks. I didn't take it out. I didn't need to. I already knew what the numbers said. He asked. Alonzo said no, and then, 4 days later, he filed for custody. Sibylla said, he asked the trustee first. The trustee said no, then he filed custody. She didn't add anything after that. She let the sequence do the work. I asked her, did Alonzo know what the custody filing was for when he denied the request? She said he knew it was irregular. He kept the record because that's what trustees do when something feels wrong. A 62-year-old man sitting in a trust administration office, reading a request that didn't add up, making a note, filing it away, not knowing he was building the case for a hearing that hadn't been scheduled yet. He just did his job, and his job created the trapdoor. I've thought about this a lot since then, whether it matters that Blaze loves our daughter, whether love and what he did to her trust can exist in the same person at the same time. I'm not sure a courtroom is where you find one, but I needed to ask the question before I could stop asking it. My phone moved across the table. I looked at the screen. The school. I picked up. The bursar's voice was still apologetic, still professionally measured. The tuition authorization was still on hold. The payment processing window closed in 48 hours. After that, they would have to begin the administrative withdrawal process for non-payment. She was very sorry. She wanted to make sure I was aware of the timeline. 48 hours. He filed an emergency custody petition. He arranged the school hold before I knew the papers existed, and now the clock his attorneys had set was running. Every hour the petition sat unresolved in the system. My daughter's school enrollment was moving closer to an administrative withdrawal. The school put it on their finest stationery, of course. That's the private school version of an eviction notice. I told the bursar I would handle it. I kept my voice the same temperature it had been when I answered. I set the phone face down on the table. Sibylla was watching me. The school, I said. I know, she said. Go this afternoon. Bring Alonzo's written confirmation that you remain the trust's recognized custodial contact until a court order changes that status. They'll lift the hold. I nodded. I looked back at the log, at the denial, at the date. 4 days. I'd sensed it from the filing date on my notepad. Now I had it not as an instinct, not as a question mark, as a timestamp, as evidence. And I wanted so badly to have been wrong. Sibylla put the log aside. She pulled out a third document, Blaze's full petition brief, 68 pages, tabbed and marked. His attorneys submitted their supporting argument this morning, she said. You need to hear it the way the judge is going to hear it. She walked me through it. The argument was this. Since the formal separation, Nerita del Prado had been emotionally withdrawn from co-parenting. She had made unilateral decisions about the child's schooling, medical care, and extracurricular activities without consultation or notification. She had, in effect, operated as a single parent, not because she was one, the custody arrangement had not been legally finalized, but because she had chosen to. Blaze Weatherby, as the child's biological father and an equal legal parent, had been functionally excluded from his daughter's daily life through systematic non-communication and independent action. I read that paragraph. I read it again. I want to tell you it was entirely false. I can't tell you that. I was withdrawn. After the separation, I'd told myself I was keeping the conflict away from our daughter, handling things quietly so she wouldn't feel the disruption. The schooling decisions, the specialist appointment, the activity schedule, I managed them because managing them felt like protecting her. I didn't think about what it looked like from outside, from his side of it. There was one line in the brief that I kept returning to. It described a specific appointment, a developmental specialist consultation I'd scheduled 6 months ago, attended alone, and not mentioned to Blaze until 2 weeks afterward when he found the appointment card in a drawer. His attorneys had written, Mr. Weatherby learned of a consultation concerning his daughter's developmental progress through a discarded appointment reminder, not through communication from the child's mother. This pattern of exclusion is not incidental, it is structural. Structural. That's the word that sat with me. Because the appointment was fine, the specialist said she was right on track, nothing to worry about, come back in a year. So I hadn't mentioned it right away because there was nothing alarming to report. I told myself that. And that's true. But it's also true that I didn't think to tell him, that he found out from a card in a drawer, that to him, structural exclusion and my version of quiet management look identical from the outside. The best lies aren't the ones that are entirely false. The best ones are the ones where you can't find the exact sentence to call wrong. How much of what I called protecting her was actually protecting myself from having to share her? I don't know. I'm not sure I wanted to know sitting in that room. Sibylla let me have about 30 seconds of that. Then she said, "The judge is going to hear both versions. Our job is to make sure they hear the sequence." Meaning not just what I did when he tried to reach the trust, what he did 4 days before he decided my co-parenting was suddenly worth 68 pages of emergency argument. The sequence is the answer. But I had to carry the weight of the true parts of his brief into that courtroom anyway. I couldn't set it down. I left Sibylla's office at noon. I had Alonzo Moreles's written confirmation in a folder, a single-page letter on trust administration letterhead stating that Nareda Del Prado remained the Del Prado Child Protection Trust's recognized custodial contact for all administrative purposes until a court order of record changed that status. Alonzo sent it over by the time Sibylla's meeting ended. He didn't ask why she needed it urgently. That's the thing about people who do their job right. They don't require an explanation to do the next right thing. I drove to the school. I didn't bring Sibylla. I thought about it, but I decided that showing up with legal representation to a school administrative meeting would signal the kind of escalation that scared people, and scared administrators make conservative decisions. I needed them to make a clear one. The school's administrative suite is the kind of room that costs money to look modest. Pale wood paneling, a small sitting area with upholstered chairs, the kind of calm that institutions use to tell you everything is under control even when it isn't. I sat across from the head of school and the bursar. I explained the situation in the language I'd prepared in the car. There was a pending emergency custody petition. It had not been adjudicated. It did not alter my current custodial status, and the trust payment should not be held on the basis of a petition that had not yet been heard by a court. Alonzo's letter was on the table. The bursar read it. The head of school read it. The hold was lifted. The bursar said she would process the authorization by end of day. She apologized, again, in the same measured, professional tone. I thanked her and stood up. I walked back to my car through the school's front path, the same path my daughter walks every morning, her cobalt backpack on, her sneakers probably still untied because she hasn't learned to care about that yet. The afternoon light was the flat, particular gray of a November afternoon that doesn't commit to anything. I sat in the driver's seat and I let myself have one breath. Just one. The specific exhale of a woman who handled one impossible thing and knows there are 2 more behind it. Then my phone lit up with a message from Sibylla. Blaze's attorneys have filed a motion to expedite the custody hearing. They're requesting day 4. Standard window is 10 to 14 days. I read it twice. He wasn't retreating. He was accelerating. And I thought, he knows or he suspects. He filed the expedited motion because he wants a ruling before the trust administration has time to formally respond to Sibylla's inquiry about the log. He needs the court to move faster than the evidence can. 2 days. The log had to be ready, Sibylla had to have the hearing strategy locked, and I had to walk into a room with him in 48 hours and watch him say everything in that brief, the withdrawal, the exclusion, the structural pattern, with a straight face. He might even mean some of it. That was the part I couldn't stop thinking about in that parking lot. Not that he was lying, that he might be telling the truth and still be doing exactly what the log said he was doing, both at once. Those aren't different people. That's the same one. I was ready an hour before I needed to leave. I don't know why I did that to myself. Got up in the dark, dressed in the dark, navy suit, the silk shell, the earrings I wear when I need to feel like the version of myself that handles things. And then I had an hour with nothing left to prepare, so I went to the kitchen. The counter was clean. I'd cleaned it the night before after Sibylla and I finished the last call. I scrubbed it down until it looked the way it's supposed to look. Bare, pale stone, room for a breakfast plate, room for a child's cereal bowl. I needed to see it that way, without the petition, without the envelope, without 3 days of legal paper telling me my family was a case file. I made coffee. I sat on the stool at the counter and I drank it and I looked at the kitchen. It's a good kitchen. We designed it together, Blaze and I, when we bought the house 6 years ago. He wanted the island larger, I wanted the window seat in the breakfast nook. We compromised on both and got something neither of us had imagined. That's what I was thinking about, sitting there an hour before I had to walk into a courtroom. Not the log, not the clause, not the 68 pages, the window seat. I've thought about that a lot since. Why the window seat of all things? I think it's because we argued over it. He wanted the island larger, I wanted the seat, and we compromised and got something neither of us had imagined. That's what I can't locate anymore, the version of us that could do that. I sat across from him while we designed that kitchen, and I trusted that we wanted the same things for this house, and mostly we did. That's what makes it hard to name clearly. Mostly he was the person I thought he was. The mostly is what I keep returning to. I helped write the trust clause that he used as a blueprint. I sat across from Alonzo Morellis 5 years ago and I signed the authorization language, and I believed it was protection because I thought Blaze and I were protecting the same thing. That was the last thing I allowed myself to feel before I stood up. Not anger, just that, the particular grief of having trusted someone at the moment when the trust was being built into something that could be used against you. I set the coffee cup down on the clean counter. I picked up my bag. I left. The family court hearing room is smaller than people imagine. 2 tables, standard proximity, close enough that if Blaze had wanted to look at me when he sat down, he could have. He didn't. That was a choice. I noticed it the way you notice things when you've been paying close attention for 4 days. Charcoal suit, white shirt, no tie. The choice of a man who wants to look like a father, not a boardroom. It's a deliberate decision. He had always been good at those. His lead attorney wore the specific expression that litigators develop for family court. Concerned but not emotional. Urgent but not desperate. It's a register they practice. I used to see it on Blaze when he was negotiating across a dinner table, the same calibrated gravity, the same willingness to let the pause do the work. I know now where he learned it, or where they learned it from each other. The argument was this. Since the formal separation, I had been emotionally withdrawn. I had made unilateral decisions about our daughter's schooling, medical care, and daily life without notification or consultation. I had operated as a single parent, not because the custody arrangement required it, but because I had chosen to. My husband, the child's biological father, had been functionally excluded from his daughter's life through systematic non-communication, and the child's well-being required the court to correct this imbalance urgently. I listened. I watched Blaze while his attorney spoke. He nodded at the right moments, a slight forward movement of the head, nothing excessive. He looked appropriately concerned. He did not look at me while the words about my withdrawal and my unilateral choices sat in the air between our tables. And then his attorney mentioned the specialist appointment, the developmental consultation I'd attended alone 6 months ago and not mentioned until Blaze found the card in a drawer. The attorney described it with the particular precision of someone who knows exactly which detail lands hardest in a family court proceeding. I watched Blaze's face receive that detail. For one moment, and I am being as honest as I know how to be telling you this, he looked like a father who had found out about his daughter's health appointment from a discarded card. Not a strategy, a wound, the kind that doesn't perform well because it doesn't need to. Then I looked back at the table. Sibylla had her legal pad open. She made 3 notes while the attorney presented. The first 2 were quick. The third she wrote carefully and underlined twice. She didn't look at me. She looked at the attorney. She was not going to counter the argument. She was going to supersede it. Sibylla stood up. She doesn't preamble. I learned that about her in 4 days of working together. She doesn't announce what she's about to do. She does it. She submitted 2 documents to the court and stated what they were: the Prado Child Protection Trust's disbursement authorization clause and the trust's request log from Alonzo Miralis, the trust's acting trustee, showing a formal access request by Blaze Weatherby 4 days before the custody petition, reviewed and denied on the same day. Then she said this, once, without inflection. 4 days before this petition was filed, Mr. Weatherby submitted a formal request to the trust's trustee for disbursement access authority. The request was reviewed and denied the same day. On the day this petition was filed, Mr. Weatherby filed the emergency custody petition now before this court. The trust's custodial authority clause is entered as Exhibit B. She sat down. She didn't argue. She didn't explain. She let the sequence sit in the room. I have sat in a lot of rooms in my life. I've sat in rooms where contracts were signed, and rooms where negotiations stalled, and rooms where the silence meant disagreement, and the silence meant agreement, and the silence meant everyone was waiting for someone else to move first. I know the qualities of silence. The silence in that courtroom was not any of those. It was the kind that happens when a room stops waiting for someone to speak and starts waiting for everyone to process what was said. The log was in the record. It could not be removed. Whatever the judge decided next, Blaze Weatherby had requested trust disbursement access authority on a specific date, been denied, and filed for emergency custody of his daughter 4 days later. That sequence now existed in a court document, in the permanent legal record. His lead attorney asked for a brief recess. The judge denied it. The reframe came instead: good faith, a father who felt excluded from his child's financial future making a legitimate inquiry. 2 separate decisions, close in timing, not causally connected. The trust request and the custody filing, independent actions driven by independent concerns. The attorney was good, I'll say that. The argument was constructed correctly. It was the best version of the argument available. The judge listened, then asked Blaze's team one question. Was Mr. Weatherby aware of the trust's custodial authority clause at the time of the access request? A pause. 2 seconds. Blaze's attorney answered carefully, a lawyer's careful answer, the kind that is technically true and strategically chosen. The judge wrote a note. He didn't look up while he wrote it. He kept writing for a moment after the pen should have stopped. Then Sibylla entered the school documentation as a secondary exhibit: Alonzo's letter, the school's lift of the tuition hold, and the record of my visit to resolve it, evidence that the pending petition had already begun affecting our daughter's enrollment and that I had acted to protect it without waiting for the court to intervene. The school had been Blaze's first point of leverage, the one his attorneys had arranged before I knew the filing existed. It became the last thing Sibylla entered into the record. That is how the school call ended. If a father uses his child's trust as a door he tries to open before he files for custody, does that make him a man who stopped being a father, or a man who was always both things at once, and the trust just showed which one moved faster? I don't know. I don't think the law knows either. The law looks at the sequence. The judge called a brief recess. I sat at my table and I did not move. Blaze's attorneys gathered their papers and went into the corridor. Blaze stood behind me, speaking to his lead counsel in a low voice. He didn't look at me when he left.
Sibylla poured water into 2 glasses from the pitcher on the table. She set one beside my hand. I looked at the glass. I didn't drink it. I knew what the ruling was going to be, not because I'd been promised anything. Sibylla does not make promises, but because I had watched the judge write his note after his own question, and I know what it means when someone keeps writing after the pen should have stopped. I've been in enough rooms to know. The water was there. I looked at it, and I thought, I came here to protect the trust. The trust is protected. My daughter's tuition will be authorized, and her enrollment will continue, and the log will live in the permanent record of this court. I won what I came here to win. What I hadn't figured out yet, sitting there with a full glass of water I couldn't make myself drink, was what winning looked like from the inside, whether it would feel like anything at all, whether relief and grief could sit in the same chair at the same time. They can.
The judge came back from recess after 14 minutes. I know because I watched the clock on the wall to the left of the bench. I needed something to count. He sat. He read from his notes without preamble. The emergency petition had not demonstrated the threshold of instability required for emergency custodial modification. The court noted, his words, noted the proximity of the trustee's denial and the custody filing as a factor in assessing the petition's stated purpose. The trust remained under current administrative authority. Standard custody and visitation proceedings may be initiated through appropriate channels if either party wished to pursue modification. That last sentence is the legal system's way of saying, this isn't over. It just isn't an emergency anymore, which is the most honest thing a court has ever said about a marriage ending. The emergency petition was denied. Blaze looked at me. It was the first time in the entire hearing that he turned his face toward mine. Not with anger. I want to be precise about that because it matters that I got it right. It was the expression of a man who had filed something correctly and lost anyway. The particular frustration of someone who believes if you follow the right process, you should get the right result. He still believes that. He will always believe that. Process over outcome is a certain kind of faith, and you don't lose it in one family court ruling. I nodded once. To the judge. Not to Blaze. I don't know why I want you to know that detail, the direction of the nod, but I do. I need you to know it wasn't for him. I gathered my copy of the documents and placed them in order in the folder Sibylla had prepared the night before. Every page in sequence. The trust clause, the log, the school documentation. In order. Sibylla said quietly beside me, "We're done here." We were. Outside, the November air was the same flat gray it had been all week. Sibylla said her goodbyes on the courthouse steps. Efficient, which I was grateful for. I didn't need to perform relief for an audience, and Sibylla has never needed to see it. She told me what came next procedurally, the filing of the ruling, the formal record, the timelines for any standard modification proceedings Blaze might choose to pursue later. She said, "You handled this well." Not warmly, accurately. Then she went back to her office because she had another case at 4. I stood on the steps for a moment. I thought about the 4 days. I keep coming back to that. Not the log, not the clause, not the 68 pages. The 4 days between when Alonzo said no and when the petition arrived on my counter. I needed those 4 days to win. Without that gap, the case is a custody dispute with a financial footnote. With it, the case is a sequence with a motive. I needed the 4 days. And I'm going to carry them the same way. I thought about the question I couldn't answer in the courtroom, whether the man who held our daughter in the delivery room 6 years ago and the man who tried to reach for trust 4 days after a trustee said no, whether those are the same man or 2 different ones. The log doesn't answer that. The ruling doesn't answer that. I'm not sure anything does. I took out my phone. I called the school. Not the bursar this time, the head of school. I asked if my daughter had had a normal day. She said yes. She said it without hesitation, which was the right way to say it. She didn't offer details. I didn't need them. My daughter was at school. She ate lunch, she came back from PE, she sat in class and had no idea. A courtroom documented the 4 days her father had needed to reach her trust while she was doing long division or whatever 6-year-olds do on Tuesdays. She didn't know. She won't know. And I don't know yet whether protecting her from ever knowing this happened is the bravest thing I've done or just the most afraid. I thanked the head of school. I hung up. I walked to my car. I did not look back at the courthouse. The trust is for her. It was always for her. He just reminded me why we built it the way we did. The morning after the ruling, I went back to Sibylla's office. Not because anything required it. The ruling was filed. The record was permanent. My daughter went to school. She came home. She had dinner. She didn't know. I went back because I had the folder. Sibylla's folder. The trust clause, the log, the school documentation, all in order. And I needed to put it somewhere that wasn't my house. I needed the case to live in a filing cabinet that wasn't in the room where I make my daughter's breakfast. Sibylla was at her desk when I arrived. She stood, which she never does. She looked at the folder in my hand, and she understood immediately. That's what 27 years of practice does. She didn't ask why I'd come in person. She just came around the conference table, and I set the folder down. I slid it across the table toward her. My hand left the folder. I stood there for a moment, looking at the dark wood table, the same table where she'd circled the clause 5 days ago, the same table where the log had first slid across to me and the question mark on my notepad had finally disappeared. The table was empty now, except for the folder. The folder was closed, the case was concluded, the child was safe. I didn't need to open it again. That was the thing I understood standing there. I didn't need to read the clause one more time. I didn't need to look at the denial date. I knew what it said. I knew what it meant. I had spent 5 days learning it by heart, and now I was leaving it on a table and walking away, and that was the right thing to do. Even though the walking away felt like setting down something very heavy you'd been carrying so long, you'd forgotten it had weight. I picked up my coat, I thanked Sibylla, I walked out of the office. The folder stayed on the table. She doesn't know any of this happened. That's the whole point. There will be other decisions, school and medical and future and time, and some of them will be contested, and some of them will be quiet, and she'll grow up in the gap between what her parents were willing to fight about and what they were able to protect her from. I don't know yet which of those she'll feel more clearly. What I know is this. The log is in the permanent record. He tried to reach the trust 4 days before he filed for her, and I protected it. That's what I did with the 4 days he gave me. If a man can love a child and use that child's trust as a door in the same breath, I don't know what to call that. I've been trying to find the word for 5 days. I don't think the word exists. I think it's just what some people are, all of it at once, and the document just shows you the sequence.
This is American Billionaire Tales, where fortune meets fate. He filed for the child. She protected the trust. The child never knew either one. Next time, a wife thought the divorce papers were the worst thing her husband could file. She hadn't seen what he sent to her board.